time for questions at the end, so I'll do my best to move quickly, but there are some important things that I think everybody should know as they contemplate potential exit, an involuntary exit in the time of COVID. As Nancy and Brian were talking about contract claims and people with executive employment agreements, one of the things you need to look to is your cause provision and whether the employer can cite a lack of funds as cause. Some contracts will say insolvency gives right to that type of an action. Some say financial distress. There's a number of different ways that employers will try and draft that provision to give them an out. But if you have an executive employment agreement with a cause provision that does not explicitly state financial distress, you are likely entitled to your severance pay, notwithstanding the company's financial distress if they're looking to move you out due to COVID. But putting aside the contract claims, I think one of the most important things that the people listening today need to hear as they think about whether or not their termination was an unlawful termination is that COVID does not bulletproof an employer from claims of unlawful discharge. And when we talk about unlawful discharge, what we're really asking is whether an employer has an unlawful motive for taking the action in question here, a layoff. In a vacuum, a lack of funds or a downsizing is a lawful reason to terminate employment. But in that context, what the courts have told us is the question focuses to why you. And so if the entire company remains, but you have been selected for layoff along with a few others, why wasn't somebody else selected? And if the reason that you were selected is unlawful, your claim can prevail. And so an employee can prove unlawful discharge through direct evidence or indirect circumstantial evidence. Some employers might say, look, COVID is hitting us hard, our business is struggling, and we're going to use this opportunity, this round of layoffs, to try and clear out some of the older employees and make way for new blood. Now, that would likely be considered direct evidence of an unlawful motive. Or maybe they will say that, it's time to trim and we can get rid of some of these squeaky wheels. People have been complaining about either failure to be, get all of their commissions or failure to have a safe work environment. Again, if an employer is so crass as to say that, you might have direct evidence, but more often than not, employers know enough about the law to avoid comments like that. And so instead, an employer is looking to circumstantial evidence, but circumstantial evidence of discrimination claims is still effective evidence. And circumstantial evidence is anything that would lead a reasonable person to infer an unlawful motive. And so I think what people often lose sight of is what you see, what you hear, what you observe, that is competent evidence. How else can you gather evidence? A couple of things to keep in mind. Many states in America have a personnel record statute that entitle people to gather information. Here in Massachusetts, an employer is obligated to provide to an employee within 5 days of a written request their personnel record, which is more than just the personnel file, not just your offer letter and your group benefit documents, but instead anything that identifies an employee to the extent it can or may be used to affect an employee's qualifications for employment, promotion, transfer, additional compensation, or disciplinary action. And requesting a personnel record is an excellent way to gather a better sense of the picture around your separation. The other thing is, to the extent that you have been let go in a group setting, when an employer terminates 2 or more employees, in order for them to obtain an effective release of age claims, they need to provide information about what's called the decisional unit. And so they would be required, in order to get an effective release, to talk to you about which groups of employees were covered for layoff, any eligibility factors they used for that layoff, the job titles and ages of the individuals, not only who were selected, but also who were not. And so all of this can help an individual gather the type of information they need to effectively assess whether they have a powerful circumstantial claim of unlawful termination. One of the things that we're seeing go into hyperdrive, frankly, as coronavirus and lockdowns take place, is the issue of company property versus personal property. Now, Brian spent some time talking about people's fiduciary duties and their obligations to the company. It's important to remember a couple of things. One, what's yours is still yours. People who have left those pictures on the wall at the office, people are making arrangements to get those things back in socially distant ways. But the flip side of that is that where you have company property, even if you've been using that laptop every day for everything for years, it is still the company's. And where people find themselves in really hot water is when they start taking unilateral action. They get that layoff notice and they get very scared that their bank statements are sitting on that laptop that they were supposed to be using only for work. The first, I think we have it on the slide, do not delete anything. Not because they're going to necessarily be entitled to see your bank statements, but because the old saying is that the cover up is worse than the crime, right? If the employer sees that a swath of documents have been deleted from their computer, they are going to assume the worst. And you may find yourself defending allegations of breach of fiduciary duty, breach of confidentiality, or other property obligations you have under contract, or far more scarily, a claim for misappropriation of trade secrets, which under the Uniform Trade Secret Act that Massachusetts has adopted, and I think every state but New York has adopted, you can be on the hook for multiple damages and attorney's fees. And so there are ways, either on your own or with competent counsel, to choreograph the management of personal property versus company property. But unilateral action can make the situation much, much worse. One of the things that we are seeing come up a lot in COVID now is issues around leave rights and reasonable accommodation rights. Now, the first thing we should talk about is the new statute, the Families First Coronavirus Response Act. Now, this has two leave provisions. One speaks to sick leave, which an individual can access up to 2 full weeks of paid leave, 80 hours, for reasons including childcare, quarantine, COVID symptoms, either on your own or someone else's. And that can be taken on an intermittent basis, and which means you can take it for a day here or there, or take it for a few hours to the extent that that's applicable. The second leave benefit provided by the Families First Coronavirus Response Act is paid medical leave, or paid family leave, excuse me, whereby an employer is now obligated to pay up to 12 weeks of paid leave for an individual who is unable to work because their children no longer have effective childcare due to COVID. The care center is closed, schools have closed, the nanny is unable to get to you due to lockdown or due to illness of their own. There are caps on that type of pay. It caps at $10,000, and the first 2 weeks are to be fully paid, and each week thereafter is at 2/3. Beyond the new statute, there's an existing framework of laws that can provide some protection. And so the Americans with Disabilities Act requires an employer to provide a reasonable accommodation to allow an employee with a handicap to perform the essential functions of their job. And so if you have a condition that makes it unsafe for you to go out in pandemic times, this is far from clear at this time, but there might be a colorable argument that you have a physical or mental condition that substantially limits a major life activity, which is the statutory definition of a handicap. You may be entitled to an accommodation if you're a high-risk individual when it comes to coronavirus. The other thing is that while the Families First Coronavirus Response Act, before I move on, I should note, at least here in Massachusetts and in many other places, a leave of absence may be a reasonable accommodation. Now, how long that leave of absence needs to be, it's a very case-specific instance, and I wouldn't go out and ask for a leave of absence as a reasonable accommodation until we all have a vaccine, but it's something to keep in mind. Beyond that, you also have the Family Medical Leave Act, which provides for 12 weeks of unpaid leave for covered employees. One last thing before we move to the other slide that I did forget to mention, I know we only have 2 minutes left, but the Families First Coronavirus Response Act applies to private sector employers with 50 or more employees, but less than 500 employees. And so it's actually a relatively narrow band of employers in the private sector that are covered by this obligation. As you're thinking about leaving, just because the company is having financial troubles doesn't mean they don't have to pay you what you are owed. And so whether at a federal level under the Fair Labor Standards Act or in Massachusetts under the Wage Act, if you have earned your wages, they are obligated to pay it to you. And I know Brian spent some time talking about choreography and making sure that you get that bonus in the bank before you make a move, legally, it's a really significant distinction because wages are protected by statute, by statutes that provide for attorney's fees and multiple damages. But if it's almost earned, you're dealing with a very different claim. And you may have an argument that if based on your past performance, you were right on the cusp of earning something before you were let go, you may be able to get some or all of that money. But you as a departing employee would much rather be looking at what is clearly an earned wage. And that's why Brian's note about choreography is so important. Similarly, as it speaks to equity or options or deferred compensation, I know when people lose their jobs, there's a lot of things going on and it's a hectic time, but looking through your equity documents to find out what exists, what persists, what your exercise windows are, and making those decisions in a timely way can really help protect you going forward. And then I think that takes us on the next slide to post-employment restrictions. I think we're run out of time to talk a lot about the new statute, but Brian did address the notion that what is reasonable is going to be the touchstone. And unfortunately, while the courts tell us that these employment restrictions are disfavored, the decisions tell us that they are enforced. And so just because what you have seems ridiculous on its face, do not assume it gets thrown out, because both the new Massachusetts statute and most states in America allow a judge to what's called red line the agreement, or blue line, I think they call it, where they literally are entitled in a judicial proceeding to modify the restriction to what would have been or what is now deemed reasonable. And so even if you have the broadest non-compete in the world, don't assume that because it's so excessively broad, it disappears. You will likely have a restriction at the end of the day. And I think with that, we're out of time, but I'd be happy to field any questions that, that people have.
Yeah, thanks, David. So we did just have a few questions come in. First, what changes are you seeing with how employers are handling severance benefits during COVID?
All right, so I'll field this question. So I guess just quickly, twofold. I really haven't seen any, as far as negotiating contractually owed contractual severance, I really haven't seen much difference. It certainly hasn't been well, it's a new ball game now, whereas, you know, executives used to get 12-month severance under their contracts. Now they're getting 6. I'm not seeing that. I mean, I think the negotiations around standard severance, what's market, what's done within an organization, that seems to be consistent, at least so far. That might change, right? Severance plans may become less generous over time, but what I have been seeing, and this was somewhat similar to what we saw back in 2008, 2009. It's more along the lines of what the company has done historically, what the precedent has been in the past, maybe outside contractually owed severance, whether it's the equities of the situation or otherwise. You know, there might be some precedent as to how companies have treated certain, certain levels of people on the way out the door, whether or not they were contractually entitled to it or not. And in that respect, I have seen a shift. And it's a little bit of, yeah, that was pre-COVID. We're now in COVID world now. And we saw a little bit of that we saw a lot of that back in 2008, 2009, when, we'd make an argument, look, the precedent for somebody at this level under these circumstances for leaving is X. And the response was, that was back in 2001. Now it's 2008. So I am seeing some of that in a COVID world. So.
Thanks, Brian. Next question, is being high risk for COVID a disability that entitles me to accommodations?
Sure, and I think I touched on this briefly, but with the big glaring neon light disclaimer that we don't know the answer to this, yes. Analytically, I think there's a strong argument that you have a right to an accommodation, because obviously it will depend on what puts you at high risk. And certain things that might put you at high risk might entitle you to other benefits. For example, at least here in Massachusetts, if you're at high risk because you're pregnant, not only do you have rights under the Americans with Disabilities Act and anti-disability discrimination statutes, you also have rights under the Pregnant Workers Fairness Act to certain accommodations. But if what's putting you at high risk is a physical or mental condition that substantially limits a major life activity, like going outside, then your employer may have an obligation to provide you a reasonable accommodation. And they, to be safe, should be engaging with you to find out what that reasonable accommodation looks like. This doesn't mean they need to do whatever you ask them to, but it does mean that there should be a dialogue taking place to figure out what can be done to allow you to perform the essential functions of your job with accommodation.
Thank you. So I think that's all the time we have for today. I'd encourage if anyone has any additional questions to follow up directly with Brian, Nancy, or David, whose contact information is on the screen. So thank you to Howard and Essex and to our panelists today. And I hope everyone found it informative, and have a great rest of your day.
Thank you.
Thank you.
Thanks, everyone.